So, are we on the verge of a major triumph for Second Amendment protections here in New Jersey? New Jersey's recent legislation blocking citizens from carrying hidden firearms in designated sensitive zones took another hit today. There's a ban on visible carrying when a state emergency is declared. There's a ban on visible carrying the moment you enter any automobile. Second Amendment supporters in New Jersey are returning to federal court yet again to challenge a state statute that prohibits concealed firearm possession, after a firearms measure intended to restrict concealed carry in New Jersey shifted from rapid advancement to being withdrawn last month. But today, a federal magistrate directing New Jersey to halt enforcement of the stringent provisions of the statute. The matter of where United States citizens may lawfully possess firearms is about to be resolved by jurists analyzing statutes drafted prior to the invention of electric power. Presently, a federal tribunal in Philadelphia is grappling with a dispute that could either broaden or severely limit firearm rights throughout numerous states, and the complete discussion depends on how we decipher rules from the 1700s and 1800s. This is not merely another firearms regulation narrative. What unfolds in this judicial chamber could establish whether you may bring a firearm into a medical facility, a recreation area, a shoreline, or even mass transit systems. The consequences are immense, and the judicial logic being employed is unlike anything we have witnessed in contemporary constitutional jurisprudence. So, what precisely is occurring here? And why ought every individual, no matter their position on firearm rights, be monitoring this with great interest? Let us examine this from the start. New Jersey enacted legislation that prohibits bearing firearms into what the state designates sensitive locations. We are referring to educational institutions, mass transit networks, shorelines, athletic venues, medical facilities, and recreation areas. The state contends these sites demand exceptional safeguarding due to the quantity of individuals assembled there and the possibility for disastrous injury should firearms be present. But Second Amendment supporters and firearm proprietors in New Jersey are mounting a vigorous opposition. They have escalated this matter to the Third Circuit Court of Appeals, and they are petitioning the complete court to rule these extensive sensitive locations prohibitions unconstitutional. Should they prevail, inhabitants with lawful carry authorization could bring firearms into a significantly broader range of congested public areas. Here is where matters become intriguing from a legal standpoint. The complete dispute centers on a Supreme Court ruling from 2022 titled New York State Rifle and Pistol Association (Firearm). This judgment radically transformed how tribunals must assess firearm regulations. Prior to Bruen, jurists could weigh public welfare concerns against Second Amendment protections. They could examine statistics, contemplate contemporary conditions, and render practical determinations about whether a firearm restriction was sensible. That methodology is now prohibited. It's now before the Assembly again, where legislators are evaluating the constitutionality of some phrasing that has since been polished. Extremely perplexing, almost intentionally so to render it extraordinarily challenging for law-abiding residents to exercise their Second Amendment protections. You cannot visibly carry in a first-class municipality without legitimate or acknowledged authorization to carry or reciprocated permit-sensitive locations encompassing recreation areas, shorelines, drinking establishments, gaming establishments, and more. New Jersey legislators are proposing some of the most severe firearm carry statutes in the nation. Sensitive locations are under scrutiny this week in the Third Circuit, and the state is in substantial defensive posture, such as the definition of an armament and additional particulars regarding so-called sensitive locations where firearms would be forbidden under the Bruen structure. Tribunals must gaze backward through history. A firearm regulation presently is only constitutional if it aligns with the historical custom of firearm regulation in America. Jurists cannot merely determine that a statute is sensible or serves public welfare. They must locate comparable regulations from the founding period or the era shortly thereafter. Now, here is the element most individuals overlook and it is the crucial aspect to comprehending this complete dispute. During oral presentations in Philadelphia this week, several jurists pressed intensely on a pivotal inquiry: should tribunals emphasize firearm regulation customs from the nation's founding in the late 1700s, or should they examine statutes from the Civil War period and Reconstruction era in the 1860s and 1870s? This might appear to be a scholarly distinction, but it alters everything if tribunals concentrate primarily on founding-era regulations. Second Amendment supporters achieve substantial victory. America in the 1790s possessed virtually no limitations on where individuals could bear firearms. There were no enormous athletic venues, no underground rail systems, no contemporary medical facilities. The scant limitations that existed applied to specific situations, such as bringing arms into legislative assembly halls or judicial buildings. But if tribunals may draw from Civil War-era regulations, New Jersey's position becomes considerably more robust. Following the Civil War, Southern states enacted comprehensive arms statutes, partly to disarm previously enslaved individuals, and Western territories such as Dodge City and Tombstone notoriously prohibited firearms within municipal boundaries. These historical illustrations provide the state far more support, no pun intended, to justify contemporary sensitive locations restrictions. So, which era governs the result? That is the critical inquiry the Third Circuit must resolve. Second Amendment supporters presenting before the tribunal made their stance evident. They believe the founding era should bear the greatest significance because the Second Amendment was ratified in 1791, and its interpretation should be fixed to that era. In their perspective, the state cannot simply declare immense categories of public areas forbidden to lawful firearm proprietors by citing Reconstruction-era statutes that were frequently motivated by racial bias rather than authentic public welfare. The state of New Jersey counters with an alternative position. They observe that the 14th Amendment, ratified in 1868, is what actually applies the Second Amendment to state administrations. Since the 14th Amendment originates from the Reconstruction era, regulations from that period should bear equivalent or even superior significance than founding-era statutes. This is a truly remarkable legal strategic contest, and the jurists appear to recognize how much depends on their response. But permit me to demonstrate why this matters outside the judicial chamber, because the practical ramifications are overwhelming. Presently, New Jersey's statute encompasses an enormous quantity of public area. Consider what qualifies as a recreation area, a shoreline or mass transit in a heavily populated state such as New Jersey. If you total every bus pathway, every rail terminal, every public recreation area and shoreline, you are effectively prohibiting firearms from a massive proportion of the locations where inhabitants actually spend their hours. Firearm proprietors contend this transforms their constitutional protection into a hypothetical one. Certainly, you can technically bear a firearm, but the catalog of forbidden locations is so extensive that in practice you cannot travel anywhere with it. That is not what the Second Amendment safeguards, they assert. On the opposing side, consider what it signifies to permit firearms in locations such as medical facilities. Emergency treatment areas are already among the most unstable environments in America. Nursing personnel and physicians report being attacked at disturbing rates. Introducing lawfully carried firearms into that environment raises serious concerns regarding patient and personnel security. The identical reasoning applies to mass transit. New Jersey Transit transports hundreds of thousands of passengers daily. Permitting firearms on congested trains and buses introduces hazards that simply did not exist when the founders were drafting the Bill of Rights. Several jurists during the oral presentation appeared genuinely conflicted about how to address these concerns. Some seemed sympathetic to the Second Amendment arguments, questioning whether New Jersey's statute encompasses too broadly. Others seem concerned about the real-world consequences of overturning restrictions in sensitive locations. What renders this dispute even more consequential is its scope. The Third Circuit encompasses Delaware, New Jersey, Pennsylvania, and the Virgin Islands. A ruling here will directly influence firearm statutes throughout all these jurisdictions, but the implications spread further. Other federal circuits are wrestling with comparable inquiries, and they are reaching conflicting conclusions. The Fourth Circuit recently affirmed Maryland's assault weapons prohibition employing a different historical analysis. The Fifth Circuit has adopted a considerably more expansive perspective of firearm rights. The Ninth Circuit is addressing bring challenges to California's restrictions when federal appeals tribunals disagree on constitutional interpretation. The Supreme Court typically intervenes to resolve the conflict. This New Jersey dispute could very well return before the justices who decided Bruen, providing them an opportunity to clarify precisely how this historical structure should function. And that brings us to the most significant inquiry nobody is discussing sufficiently. The Bruen structure asks jurists to be historians, but jurists are not historians. They are being asked to examine centuries of colonial statutes, state constitutions, territorial codes, and municipal ordinances, many of which are incomplete, contradictory, or inadequately documented. Professional historians who have submitted briefs in these disputes frequently reach opposite conclusions from the identical evidence. In one recent dispute, two expert historians examined the identical collection of colonial-era statutes and arrived at entirely different conclusions about whether they supported a particular contemporary regulation. If trained historians cannot concur, how are jurists supposed to achieve consistent results? This is not a hypothetical problem. It is already occurring. Since Bruen was decided, federal tribunals have issued wildly inconsistent rulings on comparable firearms statutes, with each jurist selecting different historical sources and drawing different conclusions. The result is a mosaic of contradictory decisions that leaves firearm proprietors, legislators, and law enforcement uncertain about what the law actually demands for Second Amendment supporters. This New Jersey dispute represents an opportunity to advance Second Amendment protections further than ever previously. A ruling against the sensitive location statute would limit the government's capacity to establish firearm-free zones and could establish a precedent that compels other states to retract comparable restrictions. For firearm regulation advocates, the consequences of defeat are severe. If court overturns sensitive locations restrictions, states will possess far fewer instruments to regulate firearms in public areas. Every new firearm regulation would need to survive a historical analysis that is inherently subjective, rendering it extremely challenging to enact statutes that address contemporary public welfare challenges. One matter is certain: whatever the Third Circuit decides, this dispute will not conclude the discussion. Second Amendment litigation has exploded since the Bruen decision, with challenges to regulations throughout the nation. Tribunals are being asked to evaluate statutes governing everything from assault weapons prohibitions to age limitations to concealed carry prerequisites, all through the perspective of historical custom. We are in the initial phases of a fundamental reconfiguration of Second Amendment jurisprudence, and the New Jersey sensitive locations dispute is one of the most crucial engagements in this broader conflict. The court has not indicated when it will deliver its ruling, but legal observers anticipate a decision within the approaching months. When it arrives, the impact will extend far beyond the Garden State. For now, firearm proprietors, legislators, and advocates on all sides are observing Philadelphia closely, waiting to observe how 18th and 19th century regulations will shape the rules for 21st century public areas. The result will reveal a great deal about where Second Amendment jurisprudence is heading, and whether the tribunals can make a 200-year-old historical structure function for a nation the founders would scarcely recognize. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.